Okay, hello, I'm back. Michael Paris, February 24, 2018, Political Science 321, Race Law and Public Policy. This is the second of two videos on the Dred Scott case, one PowerPoint presentation. So there are 34 slides on the presentation. I'm on slide number 18, and it's labeled Dred Scott, Facts and Procedural History. Wow, is this complicated? All right, so try to follow it. I've put a lot of text on these PowerPoint slides for your later reference. As I said in class, it's not the way you do a PowerPoint, but I want this to be kind of a study guide. And I do think, that this background is important for how the case gets framed and dealt with. And we're going to have to kind of look at technical legal issues to get a handle on how this works, right? And obviously, if I didn't think that the logic and critical tools you need to look at constitutional interpretation and its relation to politics and the history of American racism, I wouldn't be spending that much time on this. We could just give you the answers in Dred Scott, condemn it as racist, and move on. So obviously, I think there's something to be gained by the disciplined approach to this case. It's not an approach you're going to get in our core class or in any other history class for that matter. It's a legally inflected kind of conversation. So we do want to think about the relationship between law, politics, morality, and political conflict in particular. Okay, so Scott is born a slave in Virginia, and he is owned, his master is a guy named Peter Blow, B-L-O-W. Blow later migrates west, eventually ends up in St. Louis, Missouri in 1830, and he's taken Scott with him in this migration. Mr. Blow dies in 1832, and shortly thereafter, some of the details are kind of lost to history, but shortly thereafter, a man named Dr. John Emerson purchases Scott. And Emerson became very, almost contemporaneously with this, a surgeon in the U.S. Army. Right, so Scott is now owned by Dr. John Emerson. Slide number 19. Right. So Emerson then gets a commission, and he is assigned to an army fort in Illinois. Now, Illinois is a free state, admitted to the Union as a free state in 1818, and Scott is there with him, and they're there for about 2 years, right? A little over 2 years, in fact. So what's the legal significance of setting up this residence in a free state? What's the legal significance for Scott's status? But there's more. In 1836, Emerson is relocated by the Army to a federal fort, and this one is in the Wisconsin Territory. He's going to a place called Fort Snelling. It's near where present-day St. Paul, Minnesota is, and he's stationed there. And now this is the place where Congress has banned slavery forever in the Missouri Compromise, or the Compromise of 1820. Right? And Scott is there with him for about 2 years in this free territory. While there, he meets and he's allowed to marry a woman named Harriet, a slave woman who slave or belonged to someone else. And they get married. They actually have a ceremony. At that point, around 1838, Emerson is relocated to Louisiana, and he leaves the Scotts in the Wisconsin Territory. And in his journey south, Dr. John Emerson meets and marries a woman named Eliza Sanford. So Eliza Sanford then becomes Eliza Emerson. While in the Wisconsin Territory, we're not sure where all of the Scott's children were born, but Dred and Harriet Scott have 2 children, and one we know was born in free territory on the Mississippi River. Okay. In 1840, Emerson is relocated to Florida, and he leaves the Scotts in St. Louis, Missouri when he goes to Florida. In 1843, Dr. John Emerson dies, and his estate passes to his wife, Eliza Emerson. She used to be Eliza Sanford, but now she's Eliza Emerson, and he's given her a bundle of rights to what he owned, um, a life term estate, and some of the will provides for their children, but Eliza is in control of his estate, which includes the Scotts. For the next 3 years, 1843 to 1846, Eliza Emerson rents out the Scotts and receives the income. So these people are her property. She lets others rent them, and she benefits from the income that she gets paid. In 1846, we have a first case. This is not the case we're reading. It's a completely different case. It's a case that goes entirely through the state courts of Missouri. It's called Scott v. Emerson. So Dred Scott, in 1846, goes to the Missouri state courts and he sues Eliza Emerson for his freedom. And the way these suits were formulated was, I'm being held against my will, and they would usually allege, assault and battery, because if you were a slave, you could be hit as a matter of chastisement or discipline. But if you weren't a slave, if your legal status was that you really should be regarded as free, and somebody imprisoned you or beat you, they would be committing a crime. So this is the allegation. In 1846, historians believe that Scott is getting help from the sons of his original owner. Peter Blow's sons are helping him press this claim. So this is Scott v. Emerson. It begins and ends in state court. Slide 21. You can take it on faith that if you were Scott's lawyer in 1846, and you had his case in the Missouri state courts, on the facts of his case with these 4 years in a free state and then in free territory, you'd be pretty confident that you were going to win. The prospects for a victory looked really good. Missouri precedents, like the precedents in a lot of southern states, there were rules about how long you could go, how long you could visit, how long a stay in free territory rendered you free. And once free, always free was the logic, right? That was the legal logic. And the southern courts, as a general matter, followed this. So you would be happy. You would think this is a slam dunk. If I prove the facts, I win, right? So the case goes to trial, and the lawyers representing Scott make some technical errors. They forget to prove that Eliza Emerson actually owns the Scotts. So they lose on a technical defect, and the case is not actually tried again until 1850, right? In 1850, when it's finally processed again, the Missouri trial judge decides that Scott is free. And this is, as I said, it's a slam dunk case. Scott wins, and his stay in a free state, in a free territory, entitled him to his freedom. So he wins at trial. Also in 1850, Mrs. Emerson remarries, and oddly enough, she marries a Massachusetts guy, a guy named Calvin Chaffee, who later goes to Congress from Massachusetts as an anti-slavery advocate. But at that point in 1850, it seems that the control or supervision or maybe ownership passes to her brother, and her brother is a guy named John Sanford. Right? He's a businessman. He's a slave owner. Shortly thereafter, John Sanford comes to reside in New York City. That's his residence, although he makes frequent trips to St. Louis for his business activities. Right, so here's how the state case ends. In 1852, the Mississippi Supreme Court reverses the trial court decision. They were wrong. Scott really isn't entitled to his freedom, and the opinion is blatantly partisan, blatantly political, and really a reflection of the changing times. The Missouri court, slide 23 has a quote from the opinion. They're very honest about it. They basically say, look, we used to do this as a matter of decency or comedy or not comedy, regard for other states and their laws. We're not doing this anymore. There's too much anti-slavery sentiment, and it doesn't behoove us. They say this. It doesn't behoove us to be nice about it anymore. So he was brought back to Missouri as a slave, and under Missouri law, he's still a slave. So sort of reversion back to that status. So Scott is not going to be free. He loses in this sort of wild departure from precedent. Um, and here's how we get the federal case. Here's how the federal case arises. Is it root beer or beer? Sam Adams, brewer and patriot. So I'm on slide 24. That's my first beer, by the way. No, don't worry. So Scott sues in federal court, alleging unlawful imprisonment and battery. Now, the income from his labor has been paid into the court, for a while, so there's some money at stake. Eliza Sanford is not on the scene. She's not exercising control over him. John Sanford, her brother, is. Okay, so how is it that Dred Scott, again with the help of friends, can go into federal court and sue Sanford for his freedom? And this is a little weird. It's hard to tell what his lawyers were thinking. He had a new set of lawyers. There's a lot of intrigue and speculation about whether the case was contrived, and pro-slavery and anti-slavery forces both thought they saw a conspiracy against themselves. There probably wasn't. It's a long shot, given that everything that's happened in the state court and what the Missouri courts have said. On this one, if you're representing Scott, you think you're probably not going to prevail, but you might want to take your chances. How does he get into federal court? And here's where we get the first issue in the Dred Scott case. Scott claims that he can sue Sanford in federal court because the federal courts have jurisdiction in suits between, quote, citizens of different states. Where do we find that? We find that in Article 3, Section 2 of the Constitution. Slide 25 reproduces it, and I've highlighted the relevant language. The judicial power extends to cases, and this makes sense. You probably want federal courts to be able to hear disputes between citizens of different states because maybe one state's courts or another state's courts wouldn't be neutral fora, right? So he's claiming that he can sue for his freedom in federal court. The merits of his case are the same. These long periods of residence in a free state and a free territory render him free. He can't be re-enslaved, and I guess he wants to relitigate the claims that he lost on in state court. But can he go to federal court at all, right? So Sanford's response has a technical name at the time. It's called a plea in abatement. To abate is to stop. And it's basically a challenge to jurisdiction. It's a claim that I don't even have to talk about who wins on the law, who wins on the merits. What I'm saying as a defendant, what Sanford is saying is, you can't hear this case. You don't have the power to hear the case. Jurisdiction has to come from somewhere, and you can't hear it. Never mind how you would decide it if you could hear it. You can't hear it. There's no jurisdiction. Why isn't there jurisdiction? Well, the claim, quite blatantly, is no person of African descent could be included in that word citizen in federal court. When they wrote citizen, they meant white person. So he wants the case thrown out of court before it begins. In front of a federal district court judge, a guy named Wells, in St. Louis, in a dingy closet up above a storefront on a street, no, Corinthian columns now, he loses that point. The trial judge says, no, I can hear this case, right? Or I could, here's the catch, right? If he's free, I would hold that he's a citizen for purposes of Article 3 of suing in federal court. But you see what the judge has to do before he can decide that issue is he has to decide whether Scott is a slave or free. But the trial judge is saying very clearly, if he were free, he would be a citizen under this provision. And I would allow him to sue in court. But in order to decide whether he's a citizen, I have to decide whether he's free. And on that issue, the trial judge looks to Missouri law, as you're supposed to do, and he decides to defer to the Missouri courts about the meaning of Missouri law. So he comes down against Scott by saying he's a slave. But the important part of the opinion is if he weren't a slave, if he were a free inhabitant of Missouri, he could get into federal court. Why might that be an important conclusion, even though he's deciding that Scott loses? Well, if that ruling holds or makes sense, then any free inhabitant of a state can get into federal court to go against the citizen of another state. Well, one could imagine maybe challenges to the Fugitive Slave Law of 1850 on those grounds. Law doesn't really stay in the boxes that people want to keep it in, and if that proposition is true, that a free black person can sue in federal court, go against the citizen of another state, then there might be implications to that. Even though he's deciding under Missouri law, Scott is still a slave, right? Now that's not what Tawney decides, right? That's a very different ruling. So one approach on appeal is to leave it alone, or decide it solely on the jurisdictional issue. Say, well, Scott has been adjudicated to be a slave, and that's that. We don't have to worry about what we would do if he were free. We don't have to address that. But Tawney's answer is to address it and address it completely, right? So Scott appeals this negative decision, finding that he's a slave, to the U.S. Supreme Court. The court takes a long time to decide it. It hears 4 days of oral argument in February of 1856. That's a presidential election year. It has the case re-argued in December after the election. The election puts a Democrat named James Buchanan in the White House. He's pretty sympathetic to slavery. And the decision is 7-2. It's very confusing. All 9 justices write and publish opinions. 6 justices agree to strike down the Missouri Compromise of 1820 as unconstitutional, and that is a broad, sweeping proclamation that Congress cannot ban slavery in the territories, that slavery is protected as a property right. 2 justices, McLean of Ohio, who we saw as a dissenter in Prigg, and Curtis of Massachusetts, write very strong dissents. The Curtis dissent is the stronger one. It circulates as a political pamphlet after the decision. And just very briefly, sort of giving a flyover, again, the framing of Tawney's opinion is, 2 issues. Can a person of African descent be a citizen? Whether emancipated or not, his answer is no. So he totally separates all blacks from the Constitution. When the framers said person or people or citizen, they meant whites. They didn't mean blacks. And then he goes on to address the question of Congress's power to govern slavery in the territories, and he decides that Congress has no power to ban slavery in the territories. It's also a monumental kind of blow in favor of the South. Very briefly at the end, he addresses the significance of the stay in Illinois. That's a separate issue. Obviously, if Congress can't abolish slavery in a territory, then Scott wasn't in a territory where slavery was legally abolished. But what about the stay in Illinois? Well, there, Tawney says, it's Illinois law and Missouri law, and that's just for Missouri to decide. So again, the excerpt on Blackboard that I used from the core textbook, it's mostly about the first issue. Only on page 244 does it turn to the issue of Congress's power to ban slavery in the territories. And we come in the middle. It's kind of an incomplete discussion of that. So, slide 30. The question is simply this. This is Tawney's opening. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities, and privileges and immunities, and privileges and immunities, and privileges and immunities guaranteed by that instrument to the citizen, one of which rights is the privilege of suing in a court in the United States in cases specified in Article 3. Okay, here's his strongest point, I think, and you can criticize this argument on a number of grounds. We're going to talk about what his method is, what kind of evidence he brings forward for the proposition that no African American, emancipated or not, could be a citizen within the meaning of the Constitution. A state can make you a citizen. Massachusetts can do whatever the hell it wants. It can let you vote if it wants to, but that has nothing to do with the national Constitution, is Tawney's argument. What is this business about privileges and immunities, though? Slide 31. Article 4, Section 2, Clause 1. Can you think about what this means? This is in the original Constitution in Article 4. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. What does that mean? Why does Tawney keep coming back to that language? This case, Dred Scott, isn't really about that. The federal trial judge, Judge Wells, said, I'm not going to talk about citizenship for the purposes of Article 4. I'm only required to deal with Article 3. And we may have a different answer to whether someone can sue in court compared to the question of what rights a free person has, a citizen has, when they travel state to state. Well, the logic of his argument goes like this. The Privileges and Immunities Clause basically means that citizens in each state, when they go to another state, have to be treated as if they were citizens in that other state. They don't go with all of their privileges and immunities from Massachusetts when they go to Georgia, but Georgia has to give them what Georgia gives its own citizens. It's a non-discrimination provision. Right? So now you can start to see the logic of Tawney's claim. They couldn't have meant that. Could you imagine the southern states agreeing to have free blacks treated equally with their own citizens in their own states? Second Amendment rights? No, I don't think so. Now, that doesn't answer the question of what they were thinking when they wrote it, whether they actually thought about this particular problem of free blacks traveling. But that's not all Tawney has to say. He has a lot to say about a lot of evidence about what they thought about black people and what they thought about slavery. Now, he tends to run those things together. He tends to conflate free black and slave. Those are different legal statuses, and you want to keep those different legal statuses in mind as you read the opinion. But I do think the Privileges and Immunities Clause is kind of a point in his favor, right? That they couldn't have meant to include blacks in that because it wouldn't make any sense for the South to accept that. It would make perfect sense if they meant just white people, right? And then the other issue in terms of interpreting the Constitution, and especially on the first issue of blacks and citizenship, still on slide 31, is the question of his method. And in legal circles, in political science, Dred Scott is often invoked to attack a method that someone doesn't like, and it's known as original intent. What was the intent of the framers? How do we read the Constitution? We try to find the intent of the framers. We talked about this in class. Now, what are you finding when you find intent? Why the felt need to locate constitutional meaning in this foundational source, the intent of some collective body? Is it the framers in Philadelphia? Is it the many, many, many more people who engaged in ratifying conventions in the states? Whose intent are we talking about? How do we know it when we see it or find it? And why is it a good or bad method? There are things you can say for and against the method of original meaning or original intent. Those are slightly different ideas. Original intent and original meaning have slightly different connotations. But for our purposes, is intent a good approach? Is that what we should be looking for? Even if it is a defensible approach to constitutional interpretation, has he convinced you that he's found it? does he make a good case for what that intention actually was? And if not intent, then what? Then, Fehrenbacher told us the meaning of the Constitution should inhere fundamentally in the words of the text and only secondarily in sort of intent or purpose. What kind of logic or argument would you get if you had some notion that this text can speak to you as a text based on the words in it? Obviously, I'm a little skeptical about that because it's kind of silly to think that most of the important phrases of the Constitution can be viewed as having a plain meaning. But the text is in tension with claims about the deeply racist nature of their intentions. Right, the text doesn't quite reflect the claims that Tawney is making. The words themselves are sort of recharacterized often, right? And he will invoke, in both sections, he will invoke two of the three provisions we looked at. The Three-Fifths Compromise is never mentioned as an opinion, and that's an interesting question. Why doesn't he talk about the Three-Fifths Compromise? Probably just didn't think it was relevant, but we could think about that. But he does talk about the protection of the international slave trade for 20 years and the fugitive slave provision as clearly indicating pro-slavery sentiments, and also of a piece with other evidence, a lot of which isn't in the excerpt you have, but other evidence, a lot of evidence from state legislation and congressional action that shows a view of blacks as inferior, and that's his proposition. They viewed them as an inferior order of being and had no rights that any white man was bound to respect. Final broad question is, well, does anything hinge on this question of whether it's the judge or the Constitution that's responsible? And, what relevance might that be for us today? What relevance might that have for us today? Slide 32, just proceeding on to the second issue. And again, the logic there is he has to have a very strained reading of Article 4, Section 3. And he's basing his interpretation of Congress's power to ban slavery in the territories on the new state clause, limiting the reach of a clause that seems to give Congress power. And invoking the Fifth Amendment, slide 33, as a protection of rights. And here, he's making the following kind of point. If you go to a territory and the territorial government suppresses your speech because it doesn't like what you're saying, it's arguably violating the First Amendment and your right to freedom of speech. And the territorial government takes its power from Congress, so Congress shall make no law. It applies, right? So whatever your First Amendment right means, you clearly have it as against Congress and the territorial government. The Constitution follows the flag, and constitutional rights follow the Constitution. You have the protection of those rights, even if you're in a territory. And if those rights include a property right to your slave, big if, but if you accept that next step, then he's making a claim as a claim of right against any political majority, unless it's a state government that bans slavery. And that's consistent with his theory of the Union as a union of states and the national government as its agent. Okay, so that's it for now. I know this took a long time, but that should set up our conversation about the case in somewhat more detail with respect to the text and how how we could get farther on this question of, is this a plausible reading of the Constitution? And we also want to talk about the politics of it and the consequences of it, and the fact that they probably viewed themselves as reaching out to resolve a burning issue, thinking that reverence for the court and the Constitution would lead everyone to lay down their arms, as it were. It only inflamed things, and it became central to political rhetoric. If you read the Lincoln-Douglas debates, I mean, Lincoln's just amazing, and has a very sustained attack on pro-slavery positions on the Constitution. Um, so how does it play out in terms of its consequences? And that's going to be a question we're going to be somewhat concerned with in this course. What's the impact of Brown v. Board? What determines what Brown means? How Brown is enforced or not enforced? How Brown travels to other areas of law? Um, so what's the impact of Dred Scott? Well, it's got to be the opposite of what they hoped. They hoped for resolution, and that the court saying what the Constitution means would make things more peaceful, and they only inflamed passions. And we can't say it caused the Civil War, of course, but it certainly contributed to the polarization that resulted in Lincoln's election and secession of the Southern states and war. Okay, I'll stop there. Take good care.